Good evening, friends. My today topic is review petition in the Honorable Supreme Court. Friends, Supreme Court, being the highest court, is vested with the powers of review to correct its judgments and orders if there is an error apparent on the face or record or any of the grounds indicated in Order 47 of the Code of Civil Procedure 1908. In criminal proceeding or in civil proceeding, as the case may be. Now, friends, if we go by Article 137, it empowers this court to review its judgments subject to the provision of any law made by Parliament or any rules made under Article 145 of the Constitution. Honorable Supreme Court rules made in exercise of the power under Article 145 of the Constitution provide that in civil cases, review lies on any of the grounds specified in Order 47, Rule 1 of the Civil Procedure Code 1908. So let us dive into Order 47 of the Civil Procedure Code. It says that any person considering himself aggrieved, it is saying any person, if he is aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. First condition. Second is, if he is aggrieved by a decree or order from which no appeal is allowed. Third situation is, if he is aggrieved by the decision on a reference from the Court of Small Causes. So, friends, and if who, from the discovery of new and important matter or evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order made, or on account of some mistake or error apparent on the face of record, or for other sufficient reasons, desires to obtain a review of the decree passed or order made against him, may apply for a review of the judgment to the court which passed the decree or made the order. So, friends, this is the situation. Now, going further, in the case, what is review? Review literally and even judicially means re-examination or reconsideration. Basic philosophy inherent in it is the universal acceptance of human fallibility. Now, friends, in A.R. Amtule versus R.S. Naik, that is AIR 1984 SC at page 1531. Honorable Supreme Court has stated that it has DR's Article 137 inherent power ex debito justitia to recall an order made by it earlier if it was made by the court by mistake. Honorable Supreme Court, being the apex court, and there being no higher form where one could question any of its decisions, it is not only appropriate but also the duty of the court to rectify the mistake in any of its decisions. This is the observation in A.R. Amtale versus R.S. Naik, AIR 1984, SC 1531. The court has emphasized that the basic fundamental of administration of justice is that no man should suffer because of the mistake of the court. Ex debito justitia, the court must do justice to him. If a man has been wronged, so long as it lies within the human machinery of administration of justice, the wrong must be remedied. Some of the situations where the court may exercise such a power, I am explaining. First one is violation of fundamental rights. Second one is violation of principles of natural justice. Third one is mistake of the court. Fourth one is judgment was obtained by fraud. And fifth one is the court made the earlier orders without jurisdiction. Right of review is not an inherent right, but a right conferred by the statute. In other words, the right of review can be invoked only when it has been prescribed by any law or statute, but not otherwise, which means that a party can exercise its right of review of any judgment or order only when such a right has been prescribed by any provision of law, but not otherwise. Friends, second case is in Haryana State Industrial Development Corporation versus Mawasi 2012, Volume 7, SCC at page 200. Honorable Supreme Court has held that the right of review is a right created by statute and not otherwise. Now I am giving the particular para 9 of that judgment, what the Honorable Supreme Court said in this judgment. It will be opposite to observe that the power of review is the creature of the statute, and no court or quasi-judicial body or administrative authority can review its judgment or order or decision unless it is legally empowered to do so. Now, friends, Article 137 empowers this court to review its judgments subject to the provision of any law made by Parliament or any rules made under Article 145 of the Constitution. The rules framed by this court under that article laid on that in civil cases, review lies on any of the grounds specified in Order 47, Rule 1 of the Code of Civil Procedure 1908. So I have already read out that provision. Still, I am again repeating Order 47, Rule 1, that has been provided in the Supreme Court Rules 1930 by using Article 145. It says, any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or by a decision on a reference made from a court of small causes, and who, from the discovery of new and important matter or evidence, which after the exercise of due diligence was not within his knowledge or could not be produced by him at that time when the decree was passed or order made, or on account of some mistake or error apparent on the face of the record or for any other sufficient reason. Desires to obtain a review of the decree passed or order made against him may apply for a review of the judgment to the court which passed the decree or made the order. A party who is not appealing from a decree or order may apply for a review of judgment, notwithstanding that pendency of an appeal by some other party, except where the grounds of such appeal is common to the applicant and the appellant, or when being respondent, he can present to the appellant court the case of which he applies for a review. Friends, there is explanation attached to the rule. The fact that the decision on a question of law on which the judgment of the court is based has been reversed or modified by the subsequent decision of a superior court in any other case shall not be a ground for the review of such judgment. So, friends, these were the, you can say, copy of what is provided in Civil Procedure Code. Same provision has been made under Supreme Court Rules 2030. So, friends, this is all about little video on review. Go through it again and again so that you may get what I want to say overall about review. That's all.